Our next presentation is coming from the Office of Open Government in the Department of Justice. The Office of Open Government ensures the proud tradition of open government in Wisconsin. Wisconsin's open government laws promote democracy by ensuring that all state, regional, and local governments conduct their business with transparency. Wisconsin citizens have the right to know how their government is spending their tax dollars and exercising powers granted by the people. This presentation is a resource for the public to understand and exercise their right to access their government through open records and open meetings laws. Paul Ferguson is an Assistant Attorney General who leads the Office of Open Government at the Wisconsin Department of Justice. Paul serves as the chair of the Wisconsin Public Records Board and as the chair of the Public Records Board's Records Management Committee and Policy and Governance Committee. Welcome, Paul, and thank you.
We are going to talk about some open meetings and public records law essentials for government body members, government board members, that type of thing. And we are going to, I'm going the wrong way here. We are going to start with just a very brief background of what we do. I think it was kind of covered in the intro, but the key portions here, we're going to start with open meetings law essentials and then go to some public records law essentials in the second half. There will be, as mentioned, there'll be an opportunity for questions. So if you have any questions, obviously, please use the function that you guys have for doing so. And then also at the tail end will be of the presentation, we'll have just some information on how to reach out to our office in the future with questions. All right, so our office, again, we handle open meetings and public records law related issues and questions, open government issues, questions. We provide legal counsel within DOJ and to DOJ's clients, other state agencies, governor, legislature, that type of thing. We help develop open government policies. We have various avenues for anyone to ask questions or make complaints about public records law and open meetings law. We provide training and this type of thing that we're doing today to other state agencies, really anyone in the state. Both state, local governments, different organizations, that kind of thing. And we handle the public records process for DOJ as well. So that's the quick rundown of what we do here. At the end of the day, we're talking about government transparency. That's what we do. That's what our focus is. That's what this is all geared toward. Openness in government, transparency in government, government accountability, and both the open meetings law and the public records law in Wisconsin help to ensure that. They are essentially what are called our sunshine laws. They allow the sunlight to brighten or enlighten the work of government so that the public can see what's going on. All right, first with some open meetings law essentials for our first half here. The open meetings law basically starts with this public policy statement. And it's a fairly strong, one of the strongest public policy statements that we have in Wisconsin statutes, along with the public policy statement in our public records law, which we'll see a little bit later. Basically, it says that the public is entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of government business. Basically, the public has a right to know what government is doing. So the open meetings law, this is kind of your open meetings law in a nutshell right here. Basically, all meetings of governmental bodies must be preceded by public notice and must be publicly held in a place that is reasonably accessible and open at all times to all members of the public. That's your basics. There are some limited situations in which closed sessions are authorized. We'll talk a little bit more about those a little bit later. We're also going to touch on what reasonably accessible means as well, especially in light of the last few years as a result of COVID and all that fun stuff. All right, so the open meetings law applies to meetings of governmental bodies. So what's a governmental body? Well, chances are if you're sitting here today and listen to me right now, you are a member of a governmental body or you work with members of a governmental body. So what we're talking about today will apply to you and will apply to the body that you are a member of. Government body is defined in the open meetings law, basically means any state or local board, commission, department, council, public body, corporate, quasi-governmental corporation that's created by constitution, statute, ordinance, rule, or order. Excuse me. Basically, it means, what that means is to any kind of collective government entity, state or local level, doesn't matter. But it has to be a group of people, can't be just an individual, a group of people with a determinate membership and some sort of collective identity and purpose and expectation that it's going to act collectively in the furtherance of some sort of governmental business. Often when we're determining whether a body is a governmental body subject to the requirements of the open meetings law, we look to see how that body was created. And the most obvious or easiest ways to look or to make that determination is by looking at the state constitution, by looking at state statutes, by looking at local ordinances, that type of thing. Rule and order can also create a governmental body that gets a little more complex sometimes, especially with order. Bodies that are created by order, but that's your basic, foundation. Is we look to see how it was created first, and it doesn't matter what it's called. Doesn't matter if it's called a board. Doesn't matter if it's called a committee, a commission, council, whatever it is. It can still be a governmental body. I think the intro mentioned that I'm on the state public records board. Obviously, that's called a board, but it has committees that are called committees, but those are still governmental bodies as well, subunits of the governmental body. The definition of governmental body applies to purely advisory bodies, and that's important because sometimes we get questions where folks will say, well, the body doesn't, this group that I'm involved with doesn't have any real power, it doesn't make decisions, it just provides, say, recommendations to another body or to some other individual or group or that type of thing. And that's fine. A governmental body does not need to have any kind of final authority or power. It can be purely advisory. Governmental body also includes, I mentioned, governmental corporations, quasi-governmental corporations, and formally constituted subunits of an existing governmental body, such as a subcommittee, for example. Generally speaking, governmental body definition does not apply to groups of administrative staff of, say, a government agency or ad hoc type gatherings. So once you have defined or once you realize you're part of a governmental body, the next step is to determine when are you having a meeting. Because again, once you have that meeting, it is subject to the various requirements of the open meetings law. Meeting basically means a convening of members of our governmental body for the purpose of exercising the responsibilities, authority, duties that are delegated or vested in that body. It does not mean, or is not limited to, I should say, face-to-face gatherings or being together in the same room together. And that's something that's been in place pre-COVID era when people made the shift to Zoom meetings and team meetings and all sorts of virtual type meetings. That's been the case going back basically since the open meetings law was first enacted back in the mid 1970s. So you can have a meeting via conference call, telephone call, via Again, virtual meeting platforms like Zoom and Teams, potentially emails, potentially text messages, other forms of electronic communication or any kind of communication. So to determine if a meeting is taking place or will take place, we refer to what we call the Showers test, which is named after a court case in which the Supreme Court established a two-part test. And basically the court said that a meeting occurs whenever the purpose requirement and the numbers requirement are met. The purpose requirement basically means that the members of the body convene for the purpose of conducting governmental business. And the numbers requirement is met when the number of body members present is sufficient to determine the body's course of action. And that also includes what we call negative quorums, which is essentially the numbers present are such that they can prevent action from occurring or prohibit action from occurring. You see that often in cases where the governmental body has requires a super majority to take action. So say a 7-member body requires, say, 5 members, to take action. That basically means that 3 members of a body can constitute a negative quorum and prohibit action from occurring. If those 3 members say we're not going to vote yay on a particular agenda item, that means that 7-member body isn't going to meet its 5-member supermajority number to take action. So that's kind of what we're referring to as one example of a negative quorum. In most cases, obviously, the default's the majority. So, a majority, of members would constitute numbers sufficient to take action. So I mentioned that the body members must convene for there to be a meeting. Again, I mentioned it's not limited to face-to-face gatherings, physical presence together. It basically includes any situation in which body members can effectively communicate with one another. Oftentimes when we look to determine if the communication of members without a physical presence together constitutes a convening of members, the question that we ask is, to what extent does that communication resemble a face-to-face exchange? So when we're looking to determine, if a convening of members, is occurring through a means other than face-to-face, which is obviously the obvious, easy to spot one, are we all in the room together talking to one another, then potentially a meeting. But written correspondence, emails, phone calls, video conference calls, texting, all that kind of stuff can still be a convening. You're just looking at to what extent it resembles a face-to-face communication. Text messages, for example, if there's a group text, a group chat going on via text or some other WhatsApp or some other type of messaging service, to the extent that it's back and forth in real time, resembling a face-to-face communication, that's often likely to occur via text message, unless you're, of course, talking to someone that never responds to their text message or takes a while to respond. But the frequency of response time, the time in between sending a message, receiving a message, you can have that with the emails if you're responding in real time via email or close proximity of time to an email. The bottom line is that technology, while it helps us obviously make in our working life, it makes work, quite frankly, it makes private life much more convenient. Sometimes makes communication much easier. It does create the risk that communications could or should be held at public meetings. The private communication should be held at public meetings. And it's important to keep in mind that with the increased use of virtual workplace platforms and technology in general, there is a risk that you could be in violation of the open meetings law in the way that you're communicating with other body members. Therefore, we always advise caution. If you have questions about can you communicate electronically with other governmental body members, at the end of the day, you should always, consult your legal counsel. Whenever you have questions. Some helpful tips would include using electronic communication only for one-way transmissions, not responding or replying to communications that you get to minimize the risk of violating the open meetings law. Certainly, if you need to reply for any reason, not replying all to everyone, to all other body members, and only replying to the sender of the message. And you shouldn't use electronic communications, emails, text to debate or discuss governmental business that's related to the board or body that you're a member of, or to poll other members to see how they're going to vote on a particular issue. Those all could potentially constitute a walking quorum, which is a violation of the open meetings law that we'll talk about here a little bit more soon. Like right now, walking quorums are basically meetings of governmental body members in groups that are smaller than a quorum of the full group, but when taken together would basically be the equivalent of a quorum. So basically, they are meetings that result from a series of gatherings among body members, smaller gatherings. Again, you basically need a series of gatherings among group members, each smaller in size than a quorum, with some sort of agreement to act uniformly in some way, to take action, to not take action. Again, an insufficient number in the aggregate such that it can control the body's course of action, either through a quorum or a negative quorum. The idea of a walking quorum, the concept is intended to avoid or prevent circumventing the open meetings law by having sort of small little meetings that don't constitute, on its face, a meeting of the body, or to use surrogates or agents to basically conduct government business, poll members, reach agreements outside of a properly noticed public meeting. As maybe you're gathering, these types of walking quorum issues are very complex. They are very fact specific. Anytime you're happen to be talking to a body member and they said, well, I talked to another body member about the same issue, you got to kind of hit the pause button and take a step back to make sure that you're not creating a walking quorum issue or inadvertently taking part in a walking quorum. And that's a good time to reach out to your legal counsel with any questions you have about that situation. Mentioned all meetings of governmental bodies must be preceded by notice. And that's what we'll talk about here next. General notice requirement of the open meetings law basically says every meeting of a governmental body shall be preceded by notice. And this is one of the issues with, say, a walking quorum or a text chain or something like that, is that those types of discussions are not being held publicly. They're not being preceded by notice. The public is not being given an opportunity to attend those meetings, to have oversight over those meetings, to observe the workings of government, which is the whole point of the open meetings law, is that the public can come and observe the meeting of that governmental body and watch it and basically see what's going on. So notice has to be communicated to three separate groups. One is the public in general. Two is any news media that have filed a written request to receive such notice. And three is to the official newspaper for the community in question. So for a local government body, it might be the local newspaper. For a state governmental body, typically it's the State Journal. I think it's still the official newspaper for notice purposes. If there is no official newspaper, then you have to provide notice to a news medium likely to give notice to the area affected, which again, for a state board, obviously is the entire state of Wisconsin. Ultimately, the presiding officer of the governmental body is legally responsible for ensuring that notice requirements are met. Mentioned that I'm the chair of the Public Records Board. So ultimately, it's my responsibility to ensure that notice is provided to the public for meetings of the Public Records Board. Now, those tasks can be delegated to others, but at the end of the day, sort of the buck stops with the presiding officer. So I work with someone to draft and post and ensure that notice is provided for Public Records Board meetings. And the person does a great job in that task, but at the end of the day, if there's ever an issue, ultimately, I'm the one responsible for ensuring that that's done properly. Now, I mentioned notice has to be provided three ways: to the public, to news media that have provided written requests to receive it, and to the official newspaper in the area affected by the body. But part of notice to the public includes another sort of three-pronged approach. In order to provide a general notice to the public and the public at large, you have to use one of the following three methods: either posting in three public places that are likely to give notice to the persons affected. That's kind of like the old school, kind of, for lack of a better term, old-fashioned way, prior to the rise of the internet and the technology that we have today. It was basically posting in three public places was the recommended way of doing things. But you can also post in one public location, one physical place, and on that governmental body's internet site or website. The language of the statute says internet site, but it's basically website. And you can post otherwise. You can go above and beyond any of these avenues. You can post on your own governmental body's website. There's also DOA has a website for public notices or meeting notices, that type of thing. You can post in more than one public place and post on the internet. There's really no such thing as too much notice of a meeting of a governmental body. And also another manner of notice to the public is through paid publication in a news media likely to give notice to persons affected. Now, you might be thinking, you just said giving notice to a news medium is, or official newspaper, something like that, is one of the three required avenues of providing notice, and it is. But you don't have to pay for that notice. You don't have to ensure that they publish it. You basically provide notice to the news medium, and if they want to publish it, they will. If they don't, they don't. You're not required to ensure that they do so, unless you are using that medium to provide notice to the public in general. If you're using sort of notice to say a local newspaper or the official newspaper to provide notice to the public, then you have to pay for publication and ensure that it gets published ahead of the meeting. Timing of a notice, content of a notice, that is all provided for by the open meetings law. Basically, you have to provide notice at least 24 hours in advance. There is an exception for good cause that provides for less than 24 hours notice, but no less than 2 hours. But good cause has never been defined by the statutes or really in case law. Typically, our interpretation would be it's kind of an emergency type situation. But the standard is basically at least 24 hours in advance. The meeting notice has to include the date, time, and place of a meeting, as well as the subject matter of the meeting. Now, date, time, place, it's fairly straightforward. Subject matter is a little bit more challenging. How detailed does a notice have to be regarding subject matter? It has to be basically reasonable under all relevant circumstances of that particular matter, particular situation. What that basically means is that you're looking at the burden of providing additional details, the degree of public interest in a particular subject, whether a subject is non-routine. For example, at many meetings of governmental bodies, one of the kind of routine pieces of business is voting to approve the meeting minutes of a previous meeting. So you don't necessarily have to be very detailed when you include that agenda item, because that occurs typically at every meeting, or often does. So something like that, don't need a lot of detail, but other things you do need more detail when you're talking about specific projects, maybe, or tasks that the body's going to be discussing. If it's something of particular public interest, you want to make sure that it's more detailed than maybe usual. It's typically not difficult to provide additional details about an agenda item. It doesn't have to be 3 pages long or anything like that, or a comprehensive paragraph, but within a sentence or two, you can usually provide enough detail about what's going to be occurring at a meeting. You can't use just kind of generic type terms like old business, new business, miscellaneous business, those types of things. That's not sufficient. You got to be telling and informing the public specifically what you're going to be talking about. We're going to be talking about Project X, or discussing new work rules, regarding employee leave, or discussing the new proposals for the new plan for new playground equipment, or whatever, at the state park, whatever it is. You have to be more specific. Notice should also include any subject matter of any contemplated closed session. So if the body is thinking it may go into closed session during a meeting, you have to provide notice of any contemplated closed session and what you intend to discuss. All right, so I mentioned closed sessions, and I'll talk a little bit briefly about that here in a minute or two. But open sessions is sort of the default. Basically, all meetings, again, mentioned, have to be held in places that are reasonably accessible to all members of the public at all times. The default is that every meeting is an open session. All meetings need to begin in open session. Even if you end up going into closed session, it has to start in open session. During open sessions, again, anyone's allowed to come from the public or attend the meeting. And at those sessions, you do have to do some type of record keeping. Namely, you have to record all motions and roll call votes. Now, most governmental bodies accomplish this through meeting minutes that are often more comprehensive and more detailed than simply motions and roll call votes. But the law only requires that you record motions and roll call votes. And of course, record keeping those meeting minutes, if that's what you use, or those records of motions and roll call votes are of course public records, subject to disclosure to the public, which we'll talk about in a bit. And there also may be other different statutes that apply to your governmental body that may require meeting minutes or more detailed meeting minutes. So I'm speaking strictly of the open meetings law itself and what it requires. Again, that's probably a question for your legal counsel, if other statutes may apply to your governmental body. Now, I mentioned closed session. Closed session is the exception to the general rule that all meetings of governmental bodies must occur in open session and be open to the public at all times. There is a procedure that's required for closed sessions. One, you have to begin in an open session, so the public may be present. And then if there is an intention or a desire to maybe go into closed session, a motion must be duly made and carried to go into closed session. That motion and the voting on that motion must occur in must occur in open session. And then if it passes, then you can go into closed session. Members of the public can be asked to leave the room at that point for the closed session portion. Every vote to go into closed session must be recorded for each member. You can't just take a general vote yays, nays, you have to go, each member has to vote, you have to record it. Before voting, before making a motion to go into closed session, presiding officer must announce the statutory exemption authorizing the closed session, which are found in 19.851 of the open meetings law, and the nature of the business to be considered. So you can't just name the closed session exemption, you have to provide some more details about what specifically you plan to discuss in closed session. And the same types of information also has to go on the meeting notice. You have to cite the closed session that the contemplated closed session will be proceeding under, and the nature of the business to be discussed. Don't have a lot of time to spend. Again, we're just kind of focused on the basics here today, so we're not going to go line by line through the various exemptions. There's about just under a dozen or so listed in 19.85 of the open meetings law. More information can be found on our DOJ open meetings law compliance guide, which is available on our website. And there's other resources too with more information on closed sessions on our website. Enforcement, obviously, this is the law we're talking about. So there is enforcement of the law, either through the Attorney General, the local district attorney where the meeting occurs, or by a private citizen, essentially what we call a private relator. There are penalties of civil forfeitures per violation for anyone that knowingly violates the open meetings law, or attends a meeting, I should say, and held in violation of open meetings law. So again, this is serious. Obviously, aside from the fact that it's the law, aside from the fact that we want to promote openness and transparency in government, there are penalties attached to violations of it. An action taken at a meeting in violation of the open meetings law is voidable if a court makes that determination. So you could go through all the work of having a meeting, or excuse me, all the work of carrying out government business. If you do it at a meeting that's held in violation of the open meetings law, you may have to do it all over again. So it's not efficient either. So just some open meetings considerations in light of COVID. The last few years kind of created some challenges, of course, many challenges just in general, but to meetings of governmental bodies. And during the course of the pandemic, DOJ, through our Office of Open Government, issued 3 different advisories, which are all on our website, about how to conduct meetings in sort of the age of a pandemic, where you weren't being encouraged to be around other folks, when you had to maintain space and not all have large gatherings. And basically it focused on what reasonably accessible means. Basically reasonably accessible. So the takeaway from our advisories basically said that the type of access that constitutes reasonable access during a circumstance such as a pandemic might be different than in other circumstances and other areas. And ultimately, whether a meeting is reasonably accessible is basically a case-by-case determination. It's a factual question. Basically, what our advice says is that governmental bodies, especially in circumstances such as a pandemic, governmental bodies can meet their obligations under the open meetings law by conducting remote type meetings through video, telephone conference calls. And that advice existed pre-COVID, pre-pandemic. But obviously now we have increased use of remote and virtual workspaces like Teams and Zoom. And then you can conduct meetings that way, so long as the public has an effective way to monitor those calls, monitor those meetings. Basically, the public must be afforded the same means of attending a meeting as governmental body members. So if the body members are meeting through, say, Zoom, the public has to have an opportunity to attend via Zoom and to see the video, to hear the same audio that the governmental body members have. If a body meets in person, the public must be permitted or given the opportunity to also attend in person. It is not sufficient for a governmental body to meet in person and limit the public's attendance to remote only. Any notice to any type of remote or virtual type meeting must include instructions on how to attend the meeting remotely by including, say, a telephone call-in number, passcode to enter a meeting, or any type of login information that's required. Some best practices for meetings in the post kind of COVID world. Again, be mindful that some folks may not be able to attend meetings in person. So to the extent you can offer sort of a remote option, either, you know, kind of have an in-person meeting, but also say a virtual meeting where people can attend through Teams or Zoom, you know, that's a great idea. If you're having a remote only type meeting, some folks may not have the means to attend remotely. They might have internet access. They might not have the computer access that's needed or required, or the know-how that's required. So you might have to have a situation where you have a physical place where people can come and watch, you know, a remote meeting on a TV screen or a computer screen, that type of thing. You know, a little bit more flexibility sometimes is helpful. The bottom line is that the more access to meetings you can provide, the better. There's really no such thing as too much access in terms of, you know, the public attending meetings and observing the meetings of governmental bodies. So providing multiple options is encouraged. Some public records law and records retention essentials. Again, we're going to just hit some high points here so you're aware of everything, or aware of the basics anyway. The open meetings law, the purpose was to ensure the public's access to the meetings of governmental bodies and give them the right to attend and observe the meetings of governmental bodies. Didn't give them a right to participate, but give them a right to attend and observe. The public records law basically gives folks the right, or ensures people's right to the records of government business, the records of state agencies, the records of governmental bodies, the records of local bodies and local agencies. And it starts with, again, another strong public policy statement that records of government are presumed to be public, that there's a presumption of complete public access consistent with the conduct of government business. So any record, which we'll talk about what a record is in a second, any record of a governmental body is presumed public. The question isn't, why does the public have a right to see this? The question is really, is there any reason, legally sufficient reason, where the public isn't allowed to see this? Because the default is that they're allowed to see everything. At the end of the day, we are a government of, by, and for the people, and that's why the public has a right to see this stuff. They're taxpayers, we're the taxpayers, we're footing the bill, we have a right to know what's going on with our government. So within the public records law, there are various defined roles. The fact that you're here today means that you are with an authority. Again, either with a state agency or a member of a governmental body. Those are both authorities, and the public records law applies to those authorities. Within each authority, there is a legal custodian, someone who is vested with the authority to make custodial decisions, carry out public records responsibilities. At DOJ, that's one of my roles. Although other folks can certainly help in that process and do help in that process, especially here at DOJ. Requesters are basically the folks that get the whole public records law ball rolling. Basically, it's anyone who requests to inspect or receive a copy of a record. That's a requester. Doesn't have to be a taxpayer, doesn't have to be a Wisconsin citizen, doesn't have to be an American citizen. Basically, requesters can be anyone. They can be anonymous. They don't have to tell you who they are. They're not required to tell you who they are. They're also not required to tell you the purpose of their requests. It doesn't, at the end of the day, it doesn't really matter who they are or why they want what they're asking for. There are a couple exceptions, of course. The law often has a lot of exceptions. And one of the exceptions is where the identity of a requester is relevant, is when they are incarcerated or committed persons. They have more limited rights of access. They can only seek records that request information containing specific information about themselves or their minor children, and individuals that are seeking their own records, that are seeking records that contain their own personally identifiable information. So those are really the limited areas where the identity of a requester can be relevant. All right, we're talking about records. What's a record? Record is the short answer is basically any material that's created or kept by an authority. It does not matter its form, it does not matter its format, it does not matter where it's stored, how it's stored, if it's a paper record, if it's a PDF, if it's email, if it's an audio or a video recording, doesn't matter, it'll be a record. Records can include material that's not created by an authority, but is in the authority's possession. So, you know, if you're on a governmental body and you have a report that was created by, say, DOJ, your governmental body didn't create that report, DOJ did, but it's in your possession. It relates to government business, it relates to your body's business. That's your record for the purposes of the public records law. I mentioned again, it can include electronic records, emails, texts, social media posts of the governmental body, for example, data in a database, you know, what I often refer to as ones and zeros sort of floating around in a computer. That data is a record. And of course, virtual workplace content, things like, you know, comments made on, say, a Zoom meeting or a Teams chat, that type of thing. Things that aren't records would be published material, copyrighted material, purely personal material, drafts, notes, preliminary documents, which again, the latter category is kind of a very fact-specific situation. Electronic records, mentioned text, mentioned emails, anything that's sent on an authority's account. So say you have an official email, a work-related email, or a work phone, something like that. Anything you send on that account, on that authority's account, is a record subject to disclosure. Even if it's purely personal, even if it has nothing to do with the work of government, it's still subject to disclosure. Doesn't mean if you get a public records request that you're going to turn over the purely personal material or that you have to, but it means it is subject. So you do have to look at it and make that determination. The flip side to that is that if you use personal email account, personal phone, to send emails, to send texts that are related to government business, those emails, those texts, those calls, those are records subject to disclosure. It doesn't mean that your entire personal Gmail account or Yahoo email account is subject to the public records law. It just means that those emails, those texts that relate to government business are records subject to disclosure. Again, take you back to the definition of a record, and it does not matter where or how it's stored or in what format it is or its location. You know, we're looking at the content to determine if something is a record, regardless of where it's stored. So if you use a personal account as part of your work with a governmental body, you have to ensure that you're checking those personal accounts whenever you get a public records request to ensure that anything that's responsive to a request, that you find it and that you are prepared to provide it to the public or provide it to your records custodian to review it to determine if there's any reason it cannot be shared to the public. Receiving and processing a request. This is, again, a very general process, just to kind of give you a basics on what it often looks like. Every, governmental body, every state agency, every local government body, every local government unit may have a different twist to their process. But generally speaking, is you get a request, a public records request, a PRR is shorthand here. It's received. It can come into anyone that works for an authority, any body member. It doesn't have to be the chair of a governmental body. It doesn't have to be, the Office of Open Government at DOJ. It can come into anyone that works here, anyone that works for your agency or your authority. Once a request is received, you have to look for the records that are requested and determine if you have them. If you do have responsive records, you then have to review them to determine if there's any reason they cannot be disclosed. Again, we start with the presumption that the public has a right to see them, unless they are exempt from disclosure, either because of a specific statute or the common law. Basically, a court case has established a basis for withholding certain records, or after we apply what we call the public records balancing test, and that weighs in favor of non-disclosure. And we'll touch on that in a little bit. Any written requests that are denied in whole or in part require a written explanation, explaining the reasons for any redactions, explaining the reasons for withholding any of the records. Requests can come in any form. They can be verbal, they can be in writing, they can be via email, regular old-fashioned mail, text message, voicemail. It doesn't really matter. The requester isn't required to cite the public records law. They aren't required to use any magic words. They aren't required to fill out a form. They cannot be required to fill out a form. Oftentimes we'll get folks that simply say, I want this report. We constitute, we could interpret that, I should say, as a public records request. A requester may say, I want to make a FOIA request for, your HR policies on leave. Again, FOIA is the Federal Freedom of Information Act. It applies to federal agencies. It does not apply to Wisconsin state or local government. That said, if we get something from someone that says this is a FOIA request, we interpret it as a public records request under our Wisconsin public records law, because that's what they intend. People just tend to use the word FOIA, because they hear it on the federal level, or other states may have a state Freedom of Information Act. That's just a common phrase that's used, a term that's used. Requests do need to be sufficient. They have to reasonably describe the records or information sought, and they have to be reasonably specific as to time or subject matter. And you're allowed to reach out to a requester to clarify a request. You're not required to guess at what someone is asking for. We encourage, and there's certainly no rule against reaching out to a requester to discuss the request and find out what they're really looking for if you're confused or if you can't understand the request. Records, in order to request a record, they have to exist at the time a request is made. An authority is not required to create records in response to a public records request. You're not required to answer questions in response to a public records request. Now, you may have, a policy that you respond to questions just, to be polite, or you may have a communications team or a public relations team or something like that that answers, say, media questions. But the public records law deals solely with requests for records. Now, if you have a record that answers someone's question, it may be easiest just to provide that record, even though they didn't ask for the record. It answers the question, here you go. This answers your question. That's perfectly fine. Forward-looking requests, continuing looking requests are not contemplated by the public records law. Saying, hey, Paul, I want all of your records regarding from last week regarding this training, that's a valid request. Saying, hey, Paul, I want all the emails you're going to send next week about this training, those don't exist yet. So that's not a proper request. That's a forward-looking request. Those records don't exist yet. They might, but you have to wait till after that week if you're going to ask for the previous week's emails about a particular subject. And of course, if you have no records, tell the requester. Technically, the law only requires that you fulfill or deny a request. It does not require you to inform a requester if you have no records in response to the request. But obviously, it makes sense. It's the polite thing to do, and to tell requesters that you don't have records, if that's the case. If you've identified a record and you determine the statute doesn't prohibit its release, that the common law doesn't prohibit its release, you then apply what we call the public records balancing test. And in that situation, you review a record and you have to weigh the public interest in disclosure of a record, which is presumed, against any public interest or public policies that weigh against disclosure. Those other public interests and public policies that may weigh in favor of non-disclosure can be found in other statutes. They can be found in court decisions. They can be found in some of those open meeting requirements under 19.85 that permit closed sessions. So they can be provided anywhere. So, for example, you have state and federal law that restrict the disclosure of, say, someone's personal medical records, say under HIPAA or state law. You may have a record, say an email, that's responsive to a request, but it includes a portion that talks about someone's personal medical challenges, personal medical issues. HIPAA, state law, may not apply to that medical information in that particular email. However, you can look at those laws as evidence of a public policy that guards the confidentiality and privacy of one's personal medical information. And you can say, while no law directly prohibits the release of this personal medical information, public policy is there that weighs in favor of protecting one's personal medical information such that it outweighs the general public interest in that portion of that email. So maybe you redact the personal medical information pursuant to the balancing test based on that analysis. That's kind of what we're talking about pulling public policies from elsewhere that may weigh in favor of non-disclosure. Again, this is a fact-specific analysis done on a case-by-case basis. Identity and motive of a requester generally are not part of that balancing test. If you determine all or part of a record has to be redacted, there's no one way to do it. You can use, we often use Adobe and put those little, electronic sort of blackout lines or blackout boxes over content. But there's any different ways you can do it. There's no one way. Any redaction constitutes a denial of access. In responding to a request, I mentioned a written request that's denied in whole or in part requires a written explanation of any reasons for the denial. You can't deny a request simply because they're available elsewhere. You can't say, well, DOT has those records, or DOA has those records, go talk to them. If you have the record, you have to respond. Any denial requires what we call mandamus language, instructing the requester of their right to seek enforcement via an action for mandamus. And of course, more information about what to include, how to, the language to include in a response is available in our compliance guide. Timing of a response, basically the law requires you respond to public records requests as soon as practicable and without delay. There is no specific time frame. However, DOJ policy is that 10 business days is generally reasonable for simple, narrow, easy to find type requests. So again, if you get a request, you should try to respond as soon as possible. I'm not going to spend a ton of time here, just looking at the clock, but an authority can charge the actual necessary direct costs of responding to a public records request in limited areas, typically copying and location of the biggest areas. Location costs if they're $50 or more. But you cannot charge for the time it takes to redact and review records for redaction purposes, which is typically the longest or the most significant expenditure of time in processing requests. Enforcement, again, I mentioned a mandamus action. It's also important to note that it is a felony to destroy public records with intent to injure or defraud. So obviously don't do that. Wanted to just touch very briefly about records retention here in the time that we have left before we turn it over for questions. The public records law does govern record retention once a request is received. Basically, any requested record must be retained for at least 60 days after any partial or full denial. If you fulfill a request completely, that doesn't apply, but if you deny in part or in whole, you have to keep it at least 60 days or 90 days if the requester is incarcerated or committed. And if anyone files a mandamus action, if there's an enforcement action, obviously you can't destroy any of the requested records. Outside of that, records retention is governed by one of two statutes, either 16.61 for state authorities or 19.21 for local authorities. Records retention typically is longer than the 60 days or the 90 days set forth in the public records law for requested records. Typically, record retention is either set by general record schedules or agency specific, what we call RDAs, records retention authorizations. Again, these are all questions for your legal counsel to determine what record schedules apply to you and to your body's records, and how long you have to keep them before you can destroy them or dispose of them in whatever ways is required.
The first question comes from Peter Leviathan from our Genetic Counselor Affiliated Credentialing Board. Is the showers test purpose and numbers or purpose or numbers?
It's purpose and numbers. It's two prongs. Both prongs have to be met to constitute a meeting.
Okay. And then the second question also comes from the Genetic Counselors Affiliated Credentialing Board, which is a brand new board here. And this question comes from Michael Murillo. Are lawsuits involving the open meetings law common? By the way, the meeting name really rolls off the tongue there. Yeah, they do happen. There are, they've happened fairly regularly, that there are open meetings law enforcement. We get a lot of complaints through our office. Doesn't necessarily mean you end up in court all the time, but there's a decent amount of litigation both for open meetings law and public records law violations or alleged violations. And one more thing, Paul, as the department likes to advise the board members to create boards, set up their own email account for conducting board business is as a term of best practices. Would you agree with that recommendation?
Yes, and we've talked about that in past trainings too. Obviously we didn't touch on it here, but if you don't have, say, an agency or a body issued email account, for example, best practice, create, Paul at, board@gmail.com, just create sort of a personal email that you only use for government business, if that makes sense. So it's a great best practice.
Thank you again, Paul, for your presentation and all the information you provided us today.